Casey,
Yes.
I think we can start our webinar because I just received a text message from my colleague who is also watching to our webinar. She sent me the message that she's already watching this and she can see us. So I think,
Excellent.
first of all, dear guest, we welcome you here on our webinar. The main topic is from Russia to the United States. What to expect, what advantages and disadvantages you can have. And today we will try to explain what you should expect there. And before start, we have a small technical announcement. So Casey, concerning the language.
Yes. There is an interpretation button at the bottom of your screen. If you would like to listen to the presentation in English, there is an English channel. Dmitry, пожалуйста, скажи, послушать на русском.
Спасибо, Кейси. Наш семинар будет на английском языке. Но для тех из вас, которые хотят слушать его на английском, предусмотрена возможность синхронного перевода. Для этого вам необходимо внизу вашего экрана нажать на флажок перевода. Там есть два варианта: английский или русский. После выбора российского флага вы будете слышать синхронный перевод переводчика Кирилла.
Dmitry, could you introduce yourself and your firm?
Yeah, but I would like to do you first. So, Casey, after you, because
thank you.
It was your idea.
My name is Casey Knizer. I'm a partner at the law firm of ZUBER LAWLER, and I am in Chicago, Illinois today. Dmitry.
And my name is Dmitry Markanov. I'm a managing partner of PATENTUS here in Moscow. We are IP boutique in Russia, and we are also welcome you here.
Thank you, Dmitry. I'd like you to introduce our first guest, but first I invite everyone to get comfortable, get some tea or coffee, and settle in for our panelists. We're going to hear, after our first speaker, from some people with unique experiences and perspectives about the US legal system from the point of view of Russian companies.
So to start our webinar, we asked Mr. Vardanyan, the Vice President of Moscow Chamber of Commerce, to say hello to all the people who are here today. And Mr. Vardanyan, welcome on board of our webinar. Nice to see you. So the table is yours.
Thank you, Dmitry. Thank you, Casey. It's really very pleased to be here. And I want to say thank you very much for an interesting event. And I'm sure it will be very efficient for everybody who decided to take part in it. And I'm sure that it will give our companies and foreign companies how to go to the American market and how to be successful in America. We are very pleased that our member, the company PATENTUS, is one of the initiatives of this cooperation. And I want to say that Moscow Chamber of Commerce and Industry takes a long time for organizing international cooperation. And for us, it's one of the main targets of our job. I want to say that Moscow Chamber of Commerce and Industry is a non-commercial, non-government organization. And we are based on the law of Russian Federation and the law of Moscow. And we also have a law about Moscow Chamber of Commerce and Industry of Moscow government, of Moscow Duma. I want to say that for us, the questions of intellectual and patents is one of the important things, because we do a lot for companies, our IT companies in the foreign markets. And we do special events, special webinars. We do our special international platform, like working with exchanging opinion, marketplaces. We also have some new tradition. We organize special virtual exhibitions. Выставки, exhibitions, yes.
Yeah.
And we also do specials conferences concerning how to do business in different states. And the initiative of PATENTUS and their partners
And the ZUBER LAWLER
is very interesting for us, really. And we decided to support this event. And I think that it will give us the first step for organizing more and more such events, and to communicate Russian and USA companies. And I'm sure that when people create something together, they don't have time to war. This is why I'm sure that after that, we will see a new contract between Russian and American companies. And thank you very much, and be succeeded for this event.
Thank you, Mr. Vardanyan. We are very pleased to see you here with us. And I want to add that Moscow Chamber of Commerce is at the moment is very active in promoting Russian companies abroad, not only on the United States market. They have several of commissions, Pan-Asia and other commissions, European one, which helps Russian companies to go abroad, to contact with the representatives of Russian outside the country. So if you're interested in promoting your business abroad, I think it would be a good advice for you to go to Moscow Chamber of Commerce and to receive a support for them. And thank you, Mr. Vardanyan. And now, Casey, we are moving forward to our panelists, to people who will share, as I think, very important and very interesting information. And first speaker would be, Casey?
Our first speaker today will be Nadia Kashenka. She is the Vice President and Chief IP and Antitrust Officer at Kaspersky Lab.
Nadia, we are pleased to welcome you here, and we are waiting for your team, for your speech, because we know that your company has a very big experience on the United States market. Not many Russian companies had as long as you had. So please, Nadezhda.
Hello to everyone. So it's my pleasure to be here today. To start, my name is Nadia Kashinka, Chief IP Officer and Antitrust Officer at Kaspersky Lab. And we are doing the presentation together with Casey today. So Casey, your turn.
Thank you, Nadia. Меня зовут Casey Kenaiza, юрист, ZUBER LAWLER. Nadia and I have worked together since 2008, isn't it?
Yeah, that's right.
On US litigation. Maybe you could explain your role in all this and how it started.
Sure, yes. In my role, there are lots of responsibilities right now, starting from patenting, patent clearance, expertise, and aiding by compliance with the laws, including GDPR, of the countries where we have business in. And as IP belongs to HQ, Moscow, we need to take measures in the territories if something happens there. US, you can imagine that is the most difficult, most exciting and attractive market for everyone. And of course, we need councils in each territory. And I thank Casey for this great work. I've been working with Casey for more than 10 years. And we had multiple lawsuits in the United States, multiple difficult situations. And I greatly appreciate, Casey. Thank you for everything that you've done for us and for me. And Casey, your role?
When I first met Nadia, it was over 10 years ago, as she said, and her company had been, Kaspersky Lab had been in the United States for, what was it, 5, 6, maybe 7 years?
Correct.
But had never had any court cases or legal issues, particularly with patents. So when she came to me, the company had their very first patent case. So my responsibility was to come up with the best possible strategy for the company to protect its rights in the United States and achieve a successful result. So that's how it started.
That's right. And Casey learned very fast our motto, Kaspersky's motto. Say it in Russian, please. Do you remember? We didn't train, but do you remember?
До последнего патрона. Их патрона.
Их патрона. Correct.
Их патрона.
That's our motto. And we, every time we think about the situation from different angles and think about bullets and their bullets. So to start, how to enter to the market? Can there be any preventive measures to enter to the market? And as a cybersecurity person, as my first education is a master's degree in cybersecurity, I have this formula for myself, and I'm happy to share with all of you now. Prevention is the first and the main point. Prevention can be a set of preventive measures directed to reduce risks of getting a claim. And later on, I will speak more about this. Then the next stage is detection. Despite all preventive measures, for example, you were served a summons or CND letter, and you need to be prepared and know how to react. So you are already in the ocean, you are swimming. Then response, what to do, how to answer, and how to behave in the situation. Where is the point to contact your lawyer, your counsel in the territory. Then recovery, measures to take to eliminate the infringement. Work with architects in your company, with analysts, with other people. And later, last but not least, forensics, measures to learn how the violation happened. We need every time to understand what were the causes and what we need to do to avoid similar issues and situations later. And then when we understand what to take, how to do that, we return to the first point, to the prevention, and what can we do at this stage, how to be prepared to enter to the US market. So if you work with the technologies, we need to understand every time who are the competitors, what are the risks on the market, what are the rights of others for these technologies, and we need to make this safe road, and maybe with the help of councils like case ignizer, maybe we need to write legal opinions for that, non-infringement opinions or invalidity opinions, because we need to respect others' rights, and we need to take into account others when we do something. Also, it's very important to have conversations with external experts, I mean technical experts. I also have been working with Alex Antonov, probably he's also here and listening to us. Hello, Alex. Why it's important? When you work in your company, you have sometimes you have very narrow view on the same thing, but some people aside can view the same things differently and think differently. And that's very important to take into account how they think that, because when you later, if that happens, treat your case before jury, we will speak about this case, right?
Yes.
A little bit, yes. Then not be surprised that people don't understand you at all, because you are so technical, or you think that you're so clever, but people think differently about the same things. So that's very important to communicate with external technical experts, even if you have your own brilliant experts in your company. That's very important. Also, the laws. For example, everybody knows now GDPR, but I'm not sure that everyone knows now about Ccpa. It's the California Consumer Privacy Act, which is very similar to GDPR, but they have a little bit different requirements to make the technologies to, and all of this we need to take into account to launch a different product for California, because they have this law, or you will need to take the decision whether you will launch the product for the entire territory, or you will do some special builds for every state in the United States. So it's also very hard to understand, but laws and compliance with these laws is very important when you plan to enter to the territory. Architecture, different scenarios, you need to understand how everything works. Then, of course, you need to protect the technologies by patenting them, patent them. And you need to work with the patents. Just a couple of words about the patents and this process. Don't create new terms. Work with the regular, normal terms, and because what that would mean for us is that then you will have multiple problems with the different people discussing that or that term. And term stage is a Markman hearing in each lawsuit, patent lawsuit, is the 50% success for the lawsuit, Casey, correct?
Yes, but
yes.
I think what you're saying, isn't it, Nadia, that in the United States, patents are ultimately determined to be valid or invalid or infringed or not infringed by ordinary people on a jury, not by technical experts, and not even usually by judges, but by an ordinary person with no technical background. Yes?
Of course, yes. And I'm lucky that people like teachers and truck drivers understood me. I was so happy about that, because to deliver the idea, to express your opinion in the way that people understand technical things, just normal people, that's a big success in the market.
And what Nadia, what did we say at the company when we were testing our explanations for juries? Didn't one of your team say he imagined I speak to my grandmother? So
Oh,
babushka
right.
can understand.
Francisca babushka, French grandmother. You need to speak with French grandmother and deliver the things in that way. So even Francisca babushka will understand that. Okay. And so I just listed a few things that would probably help everyone when preparing enter to the market. And all these led us, company, to the situation that currently we have about 1,000 patents. And Casey, you can share the first slide, please. So you see how many lawsuits we have had. That's the picture from Eugene Kaspersky's blog. And I recommend everyone to read. There is a special topic, patent lawsuits, and you can read a lot of stories about our success there. And what can I say? That some lawsuits can take years, and nobody can expect the result just tomorrow, another day. It's hard. It's hard to stay with the motto, до последнего патрона, их патрона. And it's hard to motivate the team, but it's very interesting. It's very interesting to make the strategy which helps and can lead to the great success. Because when you even plan the strategy for every case, you work with the multiple questions, multiple directions. And it's also, I think, that very important to structurize your mind, how you would work with everything. Because that's not only patent cases, there are lots of other questions around every patent case. And the next slide, please. For everyone, just to remember that approach that I talked about, which is prevention first, and we spoke about some details, what I personally do to be prepared to enter to the market. That is prevention step, then detection, how to react, what to do, how to behave, recovery, measures to eliminate the infringements, and forensics, then how to learn how the violation even happened. So I hope that was helpful. Casey?
Are you ready to discuss where these patent issues are decided, at least for us?
Yeah, that's interesting topic. You know that in states, multiple courts, right? And
I'm going to put a slide on showing.
Yes, and why it's interesting, why I need to travel more than 24 hours to get to this place. Because you need to get to JFK, then to Dallas, then drive a car, get to Marshall. Yes, Casey?
Because the answer to this question of where are patent lawsuits decided is Marshall, Texas. For us, almost all of our cases were in this small town in Texas.
Right. And do you know how many people are there?
I have on the screen, it says 23,000 is current population.
Correct, yes, you have that. And what is this like for you?
Well, I know that from our point of view, to defend Kaspersky in this court, we find local attorneys who know the judges and the court personnel and the clerks who will help us, but we also travel to Texas and we test our case using focus groups and other people who can bring us people who are like the jurors who will decide the case, so that we can present our arguments to them and see if they understand it.
Yeah.
But I also wanted to show that some companies who are sued a lot in Marshall, Texas, had another strategy, which was Samsung, for example, built an ice rink right outside the courthouse.
Yes, you can see the courthouse there.
Exactly. So that people in town who might be on a jury would remember the name Samsung and think of them favorably.
And do you know what is the lowest temperature there? How could they have this ice rink?
I think it's the only one in Texas.
Okay, like in a hot country. And the population, how big is this? Can you compare for Russian audience with something? 23,000.
How would you compare that?
For me, it's like a
Tverskaya
village.
Street?
Yeah, that's a big village.
Correct. Nadia, I'm going to put on the screen the list of all our cases that we had, most of the ones being in Texas.
Okay, so for Russian audience, maybe it can be compared like the Tverskaya Street, population of Tverskaya Street, right?
Yes, that's correct. But all of these technologies, most all of these were presented in a court in Marshall, Texas, with a 23,000 people population.
Yes, that's it. We have this list, and you see our count. So troll, win, loss. We have 0.9. So this is a patent chicken. And Eugene Kaspersky had a special article. I think that I'm patent chicken, right? Okay.
Yeah, sorry, that is that refers to one of our first cases, the Lodzis case.
Okay, yes, that's right.
But I think it's worth pointing out that other companies, including Apple, Microsoft, and Kaspersky's competitors like Trend Micro and Symantec, were also sued by patent trolls in the same court. And as far as we know, those other companies all paid money to settle these cases. In the case of Kaspersky Lab, Nadia, how much did we pay?
We didn't pay anything. And in every case, there were multiple defendants. It's multiple defendants cases, and around 40. And when every time when I recall that situation when we needed to have calls, that's about 15 minutes to say hi to everyone. Like hi. What is the weather? And calls were like endless before we start to discuss the topic, the issue. And yes, that's I think that's a great success that we stayed till the end. Multiple companies preferred to pay, and their amounts were about $50,000. Large companies could pay till $5 million. And we had some situations when trolls asked us like $1 million or $500,000, and then say that, please pay us something. Can you pay us even $50,000? It was like a market, like they bought tomatoes or potato. That was funny.
All right, I'm going to put up our last slide, which shows the total amount of claims that the company was facing.
Correct. That's our calculation, that we saved $250,000 for the company. We had so many demands to pay, you can imagine that. And I'm really proud that we could win. We could win everybody, and we won over all that plaintiffs. And what also I would like to say that in Russia, IP Russian Awards, they established a special premium last year, and Kaspersky won in IP strategy. And it was a great success also for us. And I was very pleased to know that multiple juries were there who appreciated also the results. And I can speak more about every single slide, but I know that we are limited in time. And Casey, maybe you will comment on juries. Maybe that's interesting.
Yes, absolutely. As we discussed before, our presentations are geared toward the jury that we would get in our court, which in our case would be Marshall, Texas. We made many practice presentations to focus groups. Nadia participated and explained the technology from her point of view. We also, to show that the patent was covering old technology, we made demonstrations with old Mac computers from 1988 and set them up in the courtroom to run old programs for the jurors to see, so they could actually see the screen light up and see the program work. And
Correct.
our whole presentation was aimed to help the average person understand our arguments.
Yeah, I remember the situation. Do you remember that when we had a case about firewall? So imagine that firewall pretended to be patented in 1991. And of course, we found prior art in Unix systems. And we found a professor, and he had his own computer in his garage. Yes. It was for the half of his garage, it was a computer. And we helped to turn on this computer and made some screenshots for us. And we proved prior use of the technique. Do you remember that?
I do, and I also remember how after you presented to the focus group that you went to a separate room, and then you got to hear on the video what the jurors thought about you as a witness. Do you remember?
Yes, I remember that. Everybody thought that I'm Spanish, and that's okay. I was not against that. One more thing is that teachers didn't like me because I spoke so many technical language. And then after that, I understood about French grandmothers that we need to speak as we talk to babushka. Therefore, that's another recommendation. If you can try your arguments before, do that. And mock trials that we had really helped us. And that looked like in the real court. And when you enter to the courtroom, you feel this air, you feel the pressure. You see the judge, who was a truck driver, correct?
Dressed as a judge, though.
Yeah, and we had counsels. We have opposing counsel also, and that was a real story, and it helped a lot. So, if something happened in the market and you know that you need to be already in the court and present your arguments, better to do that before that, and that is a special system with the mock trials in the United States. So I spoke a lot about steps and preventive measures. Hope the audience will eat it and take into account in their work. So wish everyone be safe in the markets.
Thank you. Thank you, Nadia. Dmitry, can you come back?
Hi, I'm back. I was not displayed, but I was listening to you thoroughly. And I would say, Nadezhda, that you really have a unique experience, because I know only a few companies who managed to go to United States market. And you not only managed to go there, you managed to win 9-0 cases. So, and it was really interesting for me as a lawyer. And I would like to ask you a couple of questions, if you don't mind. And the first question is because our main topic of our webinar is to go from Russia to United States. You did it. Would you recommend to do so to other companies who are planning to go or not to go? Is it worth to or not?
That's a good question. Thank you, Dmitry. As I said, America is exciting market. People, atmosphere, techniques, businesses, lots of possibilities, etc. So, but lots of competitors are there. Just be safe and go there. Also, I know there are a lot of supportive measures also in Russia to go there. So you can cover your patent fees, and there are different programs on that. Also, people already know the lawyers, yes, in Russia, like Dmitry Markanov can contact and get help of them, and Case Igniter, who also speaks Russian. That's very good. Casey, good success with Russian. And I don't see that there are some reasons not to go.
Okay, thank you. I would add that Casey is quite fluent, especially in written one. He's sending us letters in Russian from time to time. And one more question. All of us here in Russia think that it is so expensive to patent abroad, especially in the United States, or even more expensive, ridiculously expensive to litigate there. What would you say? Is it really like that? Especially in comparison with almost $250 million you should pay, and you haven't.
Yes, we needed to pay $250,000, but we saved that money. It's quite expensive, of course, to patent. Everything costs something. To patent your technologies, to get these legal opinions, to have expertise from external expert. But I think that you can get more value being in the market. If you do everything correct, if you do all precautions, you do all preventive measures, you are safe. It makes sense to go.
Okay. Thank you, Nadia. It was really interesting. And before going